common law relationships would not have the benefit of the section or the amendment that came in 2016, because people who are living together for several years who have not gone to the church and got married, for all extent and purposes, are in a relationship. But those who are subject to rape will not have that benefit of the same protection that we afford. Yes, it can still be a rape, and it would not be a common law defense, but at the same time, we wanted to bring it on par in terms of the relationships between common law spouses and husbands and wives. The bill is also brought here as a result of a number of judicial decisions that have affected how the Sexual Offences Act has been interpreted by the courts. The language given by the lawgiver is subject to the interpretation of the courts as to what the law is. In 2022, our highest court confirmed that under the legislation, a man can in fact rape a man based on the language used in the text of the existing 1992 statute. The High Court judge in Barbados did not agree. The Court of Appeal came down on a split decision, and our final court, the Caribbean Court of Justice, looked at the proper interpretation of the act and the context in which the words were used, and found that a man could be charged for raping another man in Barbados. At the same time, the court found that the use of the gender-neutral language extended the definition to include rape, as rape, anal penetration as well. Any person, male or female, can be the offender or the victim of a rape. And this is an important step in terms of moving away from the English common law definition of rape. And the Caribbean Court of Justice, in my respectful view, was right to look at the language used by this Parliament as far back as 1992 to make that very progressive step in our law. Interestingly enough, Mr. President, the CCJ noted that there were a number of recent decisions challenging the offense under Section 9 of the present legislation, which is the offense of buggery. And a number of Caribbean and other courts in the world have found that that offense, as was, I should say, structured and thing, was unconstitutional. And while they commented on it, they didn't rule on it because that was not a matter before our highest court. But they did echo the fact that they understood that there was a case before the courts. And in May of 2022, I believe, our High Court struck down Section 9 and Section 12 of the Sexual Offences Act. Section 9 provides for the offense of buggery, and Section 12 for the offense of serious indecency. These sections attempted to regulate the sexual activities between consenting adults in the privacy of their own homes, and thus were found to have violated the constitutional right to privacy, the constitutional right to liberty, to be able to be freely able to do in private what you think as an adult is your own course of enjoyment, and also violated the right to protection of the law, because Barbados is still a signatory of a number of international human rights treaties and conventions. And Mr. President, you will know that a number of Barbadians, styling themselves as the loyal opposition, brought a petition before the Inter-American Commission to challenge a bill that is on its way through the Parliament as a breach of the convention rights under the Inter-American Convention on Human Rights. I made the point because our highest court has determined that the state cannot ratify a treaty which gives fundamental, I should say, well, conventional human rights under a convention, to obligate the state to abide by those rights, and at the same time have laws that undermine the efficacy of those rights. And that itself is a breach of your own constitution, because the constitution provides for a right to the protection of the law. So, insofar as Barbados was held to have, by the court, failed to meet our international obligations regulating the criminalization, or regarding, I should say, the criminalization of same-sex consensual acts between adults. Now, that case has prompted a lot of discussion in legal spheres, in academic spheres as well. Because while the case against Buggery has been decisively determined all across the globe as being unconstitutional or a breach of people's constitutional rights, it was the court in Barbados that struck it down, and not this Parliament by way of amendment to the legislation. But more importantly, we have in that same case found that the offence of serious indecency, which was an English common law concept, which none of us can define what is serious indecency. And therefore, the vague nature of the language fell afoul of that important rule that a person must know that the conduct in which they are engaging is contrary to the law, and it is not meant to be subjective determination of the police that has brought the charge or the investigation. Mr. President, just very quickly, the bill does propose, I should say, not purport, because my expectation is that this bill should pass, a number of new sexual offenses. We are in an unhappy state where sexual offenses are prevalent in this society. Rape is given a more expansive treatment under this legislation. Sexual intercourse with another person without the consent, and consent is delineated in 7 different specific instances under the new legislation. It really creates for a more modern reading of the Act and accounts for a number of situations where judges will not now have to use creative means to address juries' concerns about whether a particular act should lack consent in the circumstances. There are cases where people who where the courts have had difficulty in trying to address the jury's concerns about a woman who had sex because she felt that it was beneficial to her economically, and that was the only way that she could provide for her family. And whether or not that situation itself meant that she had the capacity to consent to the sexual act. What we have done in the legislation is now to delineate the circumstances in which consent is absent or can be deemed to be absent. This bill also proposes, says, well, the sexual intercourse with a minor has always been something that is abhorrent in my view. But what we have now is offenses like the touching of a minor. No longer can the canteen assistant or the teacher or the groundsman touch a little child on their person, and then the Personnel Administration Division has difficulty in determining what to do in those circumstances. There are too many people who have been suspended from the public service for interfering with our children on leave with pay, because the law is not clear. This new offense in this bill would address these things. And one of the things I would want to assure the public, Mr. President, is that when this bill is passed, it will not speak to incidents that have already occurred. But no longer will the gray area as to whether or not that is a serious sexual assault on a person, because the law does not sufficiently speak to it in clear terms, these people will not get off anymore. Meeting a minor after sexual grooming. Not only sexual grooming, but meeting them is also now a specific offense. When I was at law school, the Ghanaians used to talk about fat fouling. We call it grooming. That is a more forensic term to use it. But in the Caribbean, they have other ways of describing it. The law of incest is revised. We have known incest in our society. And I only recently, I was at a certain place and I was the last person to know of this within the context of a particular community. But it was not shocking, but still shocking to hear it. But we know, I mean, since I've had situations where we made fun of people in the community and say that John is James Bronco. And as a society, we laugh at these things, you know? But now we have put more attention to how these provisions can be delineated. Sexual intercourse with your stepchild, adopted child, is not a crime, and rightly should be. Violation of a person suffering from mental disorder or physical disability is properly delineated as well, causing or inciting a minor to engage in sexual activity, even if the adult is not participating in that sexual activity. Engaging in sexual activity with a minor can create some challenges, particularly for people who live in very small accommodations where there are large families and so forth. But that is something that we have to protect, because teachers at the kindergarten level are complaining that little boys and girls at ages 4 and 5 are simulating what they are seeing in their homes at schools. They don't know any better, but that is what they're doing. And this is a troubling feature of how we are faced with these circumstances. I know that the level of moral culpability will differ from circumstance to circumstance, but it is still, in my view, Mr. President, sufficient to make it an offense under this new legislation. Mr. President, one of the more progressive features about the bill is that under the 1992 Act, we had this very strange provision tacked on at the very end of the bill, which provided that the court, in addition to any sentence or provision, could direct that if the accused is a man, he could be whipped. That is at the end of the bill, the present law in Barbados. And that, in my view, is barbaric. Happily, we do not whip people anymore in our society. Some people might say that is why the society is as it is, but I believe that we have a solemn, fundamental duty not to exact punishments that were exacted on our ancestors as a means to physically, mentally, and spiritually demean you. That is being abolished by the bill that we are passing. Also, an important feature of the bill, and I think I need to take the time to explain it, Mr. President, is that the hearing of evidence by a complainant is now to be done in camera, in other words, in private. No longer will the courtroom be packed with journalists, waiting jurors, members of the public, or anybody else, done in camera. For minor, it was mandatory before, but for adult, it was optional. The court had to make a determination. Notice had to be given to the accused person, and the court had to strike the balance between whether the evidence would offend public morality, public decency, and the effect on the complainant. I certainly participated in a sexual assault matter in which, after we broke on the afternoon, I got a note from a member of the public which was asking me to ask a question when we resumed the next day, which I thought would have been unfair to the complainant, even although I was representing the accused at the time. And I thought that that was really, really beyond the pale. But complainants now will not have to go through that process. And I would really like to think that the country can move to a stage where, particularly for young victims of sexual offenses, to record and take the evidence as early as possible so that the complainant does not have to go through that episode 2 and 3 times. It is very difficult. Earlier this week, Mr. President, I was drawn into a case where a lady at work was sexually harassed by physical touching. And while she was not the subject of the disciplinary proceedings in the workplace, she was made to feel that she was the victim or the reason why this is so. And the line of questioning from somebody that we all know well was that, why you didn't report it immediately? And that was the line, not that the man did it. And I want to say to you, Mr. President, and to Senator Royal through you. Well, the last administration passed a sexual harassment legislation. I am yet to find a single incidence of the Employment Rights Tribunal doing a case under. I am aware that complaints have been made to the Chief Labour Officer and matters have been initiated, but not one single of these matters has ever come to my mind. I could be wrong, my research might be limited, but I'm not aware that a single case has ever come before the Employment Rights Tribunal for determination. And that is not because since the legislation has passed, people have stopped being harassed sexually in the workplace. But we have a culture of victim blaming in this society. We have a culture of not treating to these issues in a very serious way. And hopefully we can address these issues. Mr. President, I want to go very quickly into something that is important in my view, because we have had the reports coming out of the university studies, and we are aware of the police statistics as it relates to sexual offenses in Barbados. There has been a call for a sexual offenses registry, which is designed to enable government authorities to keep track of the activities of persons who have been convicted of sexual offenses, including persons who have completed their sentences. The registration is accompanied by residential address notification. You have to notify where you live. And there are restrictions in jurisdictions where you can't live near schools or daycare centers or things of that sort. Some are more invasive. You can't even access the internet, depending on the nature of the sexual offense. Not many countries have these. From my research, Australia, Canada, UK, United States of America, South Africa, Republic of Ireland, and in the Caribbean, Trinidad and Tobago and Jamaica have these registries. But what is interesting, what I discovered in my research, well, there has been a call, and I've heard it on the call-in programs a lot. I believe even Senator Walters may have spoken to it at some stage. I stand to be corrected, but or at least I heard it in this chamber coming from that side of the table. But what the research has indicated that a lot of the sexual offense registries are not really effective, because some of them are offense-based. As long as you have committed an offense under the sexual offenses legislation, you are placed on this registry. Some of them are risk-based assessments, so that if you are determined or deemed to have a propensity to commit this offense or a risk to reoffend, you will go on the register. But in most cases, it is an offense-based system. And many question the efficacy of it, because you're basically labeling a person a perpetual deviant, somebody who's to be shunned by the society. And the psychologists would tell you that is an early manifestation of what? The self-fulfilling prophecy. Likely to reoffend, because if the society thinks that you are a sexual deviant, then what could be more burdensome than going back up to prison for something that everybody thinks that I am? And that has been found to have been a troubling reality in relation to that. So as a small society, I know Trinidad has the legislation in place. They have notification requirements, and the police are to be notified everywhere you go. One deficiency you find is that in societies like ours, where we have a high level of deported people who are on sexual registries in the United States, UK, they come back. And Trinidad has found that, but the legislation does not provide for them to be registered or monitored in the way that they would have been in the country which they left. But Trinidad has now made their sexual offenses register public so people can be placed on it. But we don't have enough data coming out of the Trinidad experience because they have only started that public register in 2019. Mr. President, the breadth of sexual offenses, and in this legislation we have a lot, should be some cause of concern if we were to go for a sexual offense register. Not all offenses carry the same level of moral culpability or public outrage. They can range from two minors experimenting and being caught, and then they face the criminal juvenile justice system. Do we put them on a register at age whatever? They're on it. It could be indecent exposure, or it could be something more dastardly like rape. It could be as nebulous as soft porn being exposed, children being exposed to it. So, do we lump all sexual offenses as a basis to put people on a register? We have, therefore, to look at that question of whether we should explore it. I know the Learned Attorney General has said it is a matter that is under consideration, and I believe that we should continue to look and evaluate the studies that have been done in other countries as it relates to these things. There is a number of studies coming out of the United States, because out of all the industrial countries, the United States is the only one that makes their register accessible to the public, whereas in the UK, Australia, Canada, and other jurisdictions, this register is only accessible to the police and to the state authorities that are in need of that kind of information as to the whereabouts, locations, and so forth of people. I suppose if you are planning to establish a school, you don't want a convicted pedophile or locate a school in the area where a convicted pedophile lives. Now that could be problematic in a small country like Barbados, because where you put them, and it is not a funny thing, because when we hear about the statistics about the prevalence of sexual violence, if we were to put a register in place, you could really have serious limiting impacts on the mobility of people in a small country like Barbados. And that itself, as these studies have shown, can have its own reverse deleterious effects. So that we have a lot of work to do, and the legislation that we are passing today in the Senate will not solve this problem of sexual violence on our people, men, women, children, all subject to this. It makes better provision for the law, and we are modernizing the law in a significant way today. We have listened to the determinations of the court, and we have tried to keep the law lockstep with more progressive interpretations so that we can deal with the sexual violence in a modern contemporary framework. And the bill does, in my mind, achieve a lot of this. I can go into a lot more, because the bill does modernize the law in relation to cooperation, a number of different things. And time does not permit a full exhaustive, detailed discussion as to how the law is modernized. But I do commend this to the chamber, and I wish to signal that it is really a step up, and the government should feel confident that the legislation no longer will face the judicial scrutiny of having imprecise, vague, outdated language that doesn't necessarily accord with how the courts will interpret criminal law and penal statutes, and it also does not offend the constitutional rights of our citizens. Mr. President, I'm obliged to you. Thank you.
Thank you very much, Senator Nichols. Senator Dr. Haynes.
Thank you for recognizing me, Mr. President. I just wanted 2 minutes quickly to speak to this important piece of legislation. As Senator Aldwillie would have spoken to earlier, we are in the middle of the 16 days of activism, and I think it's really important that we have committed to staying to this late hour to get this legislation passed. The opening lines in Law & Order SVU, that TV series, reminds us that the sexually based offenses are considered to be particularly heinous in the criminal justice system, if anybody remembers. And that's because the human body is the crime scene. And I just wanted to take 2 minutes to acknowledge the victims of these crimes and to acknowledge the important work that we're doing tonight to increase the scope of protections for all people, not just men and women, but gender minorities, people with disabilities, because what we do know, as Senator Worrell, the leader of opposition business, would have spoken to, we're seeing an increase in sexual violence, but what we also know is that disproportionately, these acts are perpetrated against women, LGBTQ youth, people living with disabilities. And we can't take for granted that we're not here because of us, but because of the advocacy of civil society organizations that nobody's acknowledged to this point, Equals, ECAID, Butterfly, who brought a legal challenge to the constitutionality of 2 particular sections in the parent legislation. And it is that has triggered us being here. So I wanted to take the opportunity to recognize the important work of civil society in bringing us here tonight. And so I didn't want us to wrap up tonight without that recognition, because it actually has given us an opportunity to make our laws better. And I think it's especially important on the eve of the 3rd anniversary of our transition into republic, a republic that's supposed to be a place where every single Barbadian has a place. So, Mr. President, with that very brief intervention, I'm obliged.
Thank you very much, Senator Dr. Haynes. Any other speakers? Senator Cummings, please wind up.
Thank you very much, Mr. President. I want to express appreciation to all of the honorable senators who have spoken on this bill. It is an important piece of legislation, and as we've heard from all of the honorable members who have spoken, clearly it is a societal issue and a wrong that is being righted. The opportunity to right the original wrong that went before the court, and then the opportunity to expand the scope of the amendments being made to the legislation. And that, Mr. President, is what we are here to do on any given day in service to people. And so, Mr. President, with those few words, I beg to move that this bill now be read a second time.
The question is that this bill be read a second time. Will those honorable senators in favor please say aye? Aye. Those against please say no. We think the ayes have it.
I had stood, Mr. President, to propose the appointment of an acting deputy president in the person of Senator the Honorable Lindell Nurse for the remainder of today's sitting.
The question is that Senator the Honorable Lindell Nurse be appointed deputy speaker for the remainder of today's, deputy president for the remainder of today's sitting. Will those honorable senators in favor please say aye? Aye. Those against please say no. The next ayes have it. Senator Nurse, thank you for agreeing to serve as deputy president.
Mr. President, I beg to move that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that I do not leave the chair and the Honorable the Senate resolve itself in a committee for further consideration of this bill. Will those honorable senators in favor please say aye? Aye. Those against please say no. We think the ayes have it.
Senators in committee.
Mr. Deputy Pence, may we take the clauses in 3 parts? Clauses 1 to 10.
Mr. Deputy Chairman, I beg to move that clauses 1 through 10 do not stand part.
The question is that clauses 1 to 10 do stand part. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it.
Clauses 11 to 20.
Mr. Chairman, I beg to move that clauses 11 through 20 do now stand part.
The question is that clauses 11 through 20 do now stand part. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it.
Report.
21, 23.
Oh, I'm sorry. Clauses 21 to 23.
Mr. Chairman, I beg to move that clauses 21 through 23 do now stand part.
The question is that clauses 21 to 23 do now stand part. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do now report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passing of one bill in committee. Senator Cummings.
Mr. President, I beg to move that this bill now be read a third time.
The question is that this bill be read a third time. Will those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Sexual Offences Amendment Act of 2024.
The question is that this bill be now passed and be cited as the Sexual Offences Amendment Act 2024. Will those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it. This bill is now passed and so cited. Senator Cummings.
Mr. President, I think that this is a moment that all honorable senators have been waiting for me to say all evening. This brings us to the end of government's business for today's sitting. And I want to, again, as I started, I want to close and express appreciation to all honorable senators for literally just slugging it out from this morning through to tonight on the eve of independence. And I wish all of the honorable members, I wish all of Barbados a happy independence. I look forward to seeing everyone at the parade tomorrow as we celebrate our Independence Day. And so, Mr. President, I beg to move that the Senate is adjourned sine die.
Senator Worrell.
Mr. President, I would like to join the leader of government business in speaking on the adjournment and wish all Barbadians a happy 58th anniversary of independence, and also to thank the workers here at Parliament and the police service who also stayed with us throughout this. So make sure that tomorrow you get out there and enjoy your conkeys and enjoy all the independence festivities.
Senators, please, senators, the business is not finished. Please, let us maintain due decorum. I know you're excited at the prospect of a little freedom in a few moments. Let me join with the leader of government business and with the leader of the opposition and the independent senators in wishing all of you and the staff and the general public in the hearing of our voice, on behalf of the entire Honorable Senate, wishing everyone a happy independence. I look forward to seeing all of you tomorrow as we celebrate our 50th anniversary of our independence. I wish everyone a good weekend, and we look forward, Senator Cummings, when you will let us know the next you will have us here for a short while. So thank you very much, all the very best for your independence, and thank you for such spirited and wonderful contributions today, notwithstanding the length of the day. The quality of your contributions did not wane as time went on. You've shown your intellectual and physical stamina. Thank you, well done. The question is that the Honorable the Senate do now adjourn sine die. Will those honorable senators in favor please say aye? Aye. Those against please say no. Meeting is the ayes have it. The Senate is adjourned sine die.